and not be a monologue. Monologues are very, very boring. We'll try to avoid that. So the first case that we are going to deal with is this one. Arca Industry versus HR Commercial. Okay, that is one case, and Welspun Steel versus Arca Industry, another case. But both of them disposed of by the common judgment dated 26th August 2022. Parties in the case, the corporate debtor here was IBC Shipyard Limited, which is in liquidation. The appellants in the first petition was Arca Industry, which was the anchor bidder in the second Swiss challenge in a sale by private treaty process. When we come to the facts of the case, you will understand where this fits in. The second case, which was also dealt with in the same judgment because of the identical facts and issues before the court, was filed by Welspun Steel, and in this the first respondent was Arca Industries, of course, and the liquidator was obviously a common respondent in both cases, in both the appeals. Now, what are the issues in this case as framed by the SC? In fact, the judgment itself very clearly states this. The first issue was whether the respondent number 2, that is a liquidator, in both cases it is number 2 is a liquidator, was justified in discontinuing the second Swiss challenge process for the sale of a part of the assets of the corporate debtor, where Arca Industries, the appellant, had already been declared as an anchor bidder. So that process of a Swiss challenge for a part of the assets where somebody is declared as the anchor bidder was cancelled, and the liquidator opted to go for a private sale process through direct negotiations in respect of the composite assets of the CD. So the mechanism, the process which was ongoing at that time, which cancellation is under challenge, was only for the material lying in the shipyard, largely what you can say plant and machinery, scrap, etc. And it was then opted, that was cancelled, and the liquidator opted for a composite sale of both land, building, etc., and the entire, in fact, all the assets of the CD at the H. This relates to the H unit. If so, if that part is, that means whether if the liquidator was justified in doing so, was the enclad justified in directing the respondent number 2, that is the liquidator, to restart the entire process of private sale after issuing an open notice to all prospective buyers, not just those who had with whom the liquidator was in discussion, but again, like by way of a public notice. A private sale should be conducted after issuing a public notice so that more people can participate. That the framing of that issue itself would tell you the contradiction inherent in such a stance. Okay, brief facts of the case. In the ABG Shipyard case, the liquidator had attempted actually initially to sell all the assets of the CD as a whole and piecemeal plus as a whole, in the sense this option given that piecemeal offers could also be made in various auctions, and offer could be made for the composite assets 5 times prior to this, where all the disputes started, but with no success whatsoever. Then the liquidator approached the NCLT for seeking permission to sell the assets of the corporate debtor through private sale. Now, the judgment itself does not say why at this stage the liquidator thought that a private sale would be more beneficial. There are situations where a private sale does attract more bidders, or maybe a bidder, which a private public sale may not. But such situations would be rare, but there must have been a reason why an application was made. Maybe certain parties approached after the failed auctions, the liquidator, and said, okay, we are interested in a private sale process. So the liquidator approached the NCLT seeking permission to sell the assets. through private sale. Then there was a meeting of the stakeholders, 2021. Okay, at that time the SEC was not what the SEC is today after the amended liquidation regulations. So it was more consultative than the sort of powers that are given to the SEC today. Now, the stakeholders resolved that the prospective bidders who wish to participate in this private sale of the Dahej material should be encouraged to do so by adopting a Swiss challenge process. A Swiss challenge is basically a two-step process where at the first stage, an anchor bidder is identified, whoever, either it could be an unsolicited bid, only bid received, or it could be more than one, out of which one is identified as the anchor bidder. And then such anchor bidder is then given the right of first refusal when the actual challenge mechanism takes place. Now, the first Swiss challenge process did not succeed because there was a person who had offered the highest offer, but failed to deposit the EMD, and hence it was a failure. Now, in the second round of the same process, and second round was held. Now, as against the base price that was fixed for that round of 460 crores, the appellant, in this case, RK Industries, they made a bid of 431 crores. Now, usually in such a case, when an offer is below the base price, it usually doesn't get accepted. But this was a peculiar case where multiple auctions had failed. The proceedings had been going on for years. And so I think the liquidator and the stakeholders, in their commercial wisdom, decided to accept this 431 crore offer and declare the RK Industries as the anchor bidder. Now, after this anchor bidder was selected, the liquidator published an ad now seeking bids to bid against the anchor bid. Then this is the challenge mechanism, Swiss challenge mechanism. And 4 or 5 respondents actually made bids in that. But before this process could be completed, one of the bidders, the respondent number 1 in the case, HR Commercial, who was also participating in that, approached NCLT Mumbai with certain grievances. And as an interim relief against that IA filed by that party, NCLT directed the liquidator to carry forward the entire process up to announcement of who is the highest bidder, but not proceed beyond that. That means not conclude the sale per se. Now, this case filed by HR Commercial is still pending in NCLT Mumbai, when the liquidator is now approached by Welspun, which is the respondent number 7 in the first appeal and the appellant in the second appeal. Now, Welspun made the offer to the liquidator that they are interested in buying the entire assets, all the immovable and movable put together as a composite sale, that shipbuilding yard along with metal scrap, etc. And the offer that they made was considered to be much more attractive, not only by the liquidator, but also by the stakeholders concerned. And based on that, the liquidator approached the adjudicating authority. And this is when the liquidator seeks permission to continue the sale process by way of a private sale treaty. Okay, no Swiss challenge mechanism, nothing, but directly. And this would effectively involve the cancellation of the ongoing process of Swiss challenge, which had been initiated. Second round had already commenced. Now, this NCLT granted permission to the liquidator to do so. Okay. Now, what are the submissions made by the parties? Broadly, there is only one submission made by RK Industries, that the liquidator should not have been granted such permission by the NCLT, because there is an ongoing process publicly announced in which there are many participants, including the appellant. and it is at an advanced stage. The first round stage is already over of identifying the anchor bidder. The second stage is ongoing where bids have been invited, and it would be arbitrary and would also cause significant loss to the appellant. And on those grounds, the Arca Industries filed the appeal. Okay, that is the primary argument that they made in their appeal. Now let us look at the observations of the court in this matter. Court here is the Supreme Court. Now, first thing they looked at was what are the documents which form the basis of the authority under which the liquidator decided to cancel the ongoing process and opt for a new process. So these were the anchor bid document, that is that stage 1 document, and the second Swiss challenge process document, first having been failed, so it was the second. On perusing that, the court noticed that there is no doubt that all the prospective bidders had been informed by the liquidator that he reserves the right to abandon, cancel, terminate, or waive the said process or any part thereof at any stage, a very wide set of powers. Okay. That issuance of the anchor bid document by itself does not create any binding obligation on the liquidator to proceed with the sale in such manner. And the anchor bid document by itself did not constitute an offer or commitment or an assurance of the liquidator. Now, identical rights were reserved with the liquidator even in the Swiss challenge process document. So anchor bid document and Swiss challenge document had vested similar rights in the liquidator to cancel, modify, waive, abandon, terminate, whatever the process at any stage. Now, in the Swiss challenge process document, there was a schedule 4, which went even beyond what was there in the anchor bid document, which entitled the liquidator to include a bidder to participate in the sale process at any stage, which means that it is not confined to those who participate at the initial stage, but the liquidator had the right to invite anybody else or include anybody who has made a request to be included at any stage. And this schedule 4 also had a clause which said that the liquidator could even decide to sell the composite assets of the cooperative. Now, the court is observing that merely because the appellant, Arca Industries here, had submitted a bid under the anchor bid document and was declared as the anchor bidder in the second Swiss challenge process, that by itself did not vest any right on it to insist that this process should be taken to its logical conclusion. Now, the court makes a scathing observation here. It says that this appellant has been harping about its vested rights, which have allegedly accrued in its favor, but it is conveniently forgetting that on 23rd March 2021, by way of an affidavit, it had unconditionally and irrevocably undertaken to be bound by all the conditions of the process documents. Now, based on this, that the anchor bid document conditions, the second Swiss challenge process document conditions, and the affidavit by the appellant, acknowledging that the liquidator was well empowered to do whatever was mentioned as the powers of the liquidator in those documents, there was no justification to discontinue the second Swiss challenge process. Such an argument could not be made by the appellant that it cannot be discontinued. The court goes on to say that no special rights came to be vested on the appellant as the anchor bidder. Whatever the liquidator did during the entire process was back to the hilt by the stakeholders, including discontinuing the Swiss challenge process and wanting to go in for a private sale of the consolidated assets through direct negotiation. and the anchor bidder had no vested right beyond the right of first refusal, which was, of course, its right all along because it was the anchor bidder. And the Swiss challenge process is just another method of private participation that the courts have recognized over a period of time that it is a transparent process. The court says that the IBC has left it to the discretion of the liquidator. Okay. Now, this is an important statement in this because it will be, this is the part that will be applicable in general because it's in relation to the law IBC itself, not just the facts of the case. That IBC has left it to the discretion of the liquidator to explore the best possible method for selling the assets, which includes private sale through direct negotiation. And why? Because the object is maximizing the value of the assets, right in the preamble. Now, the court observes that in this case, in the facts of this case, there was good reason for the liquidator to halt the process and, consider definitely the private sale process with the offer made by Welspun, because one, it was for a significantly high value, though it was a combined offer. And more importantly, that this was the preferred choice all along of the liquidator and the SEC, though 5 auctions had failed. And in terms of the time required complete the entire liquidation of the company, it would have been highly extended time. It would have taken probably years, maybe more than 1.5 years, as was estimated. That first stage, the material is sold off. That would take 15 to 18 months to be removed because this huge material lying in the shipyard. Post which a second stage will start for selling the land, and that might take some significantly more time. So the entire process would get dragged on for maybe a few more years. At the initial stage, they did go for that because they did go for the sale of material alone, primarily because there was no bid for the entire thing. But now that there was a party who was willing to buy all the assets together as one composite whole, it made a lot of sense, both in terms of commercially by value, but also in terms of the time that it would take to complete that process. And in general, in liquidation, the longer it takes, the less is the realization. Now, in the end, the court makes certain observations which are now general in nature, and they are also backed by previous judgments of the court in other matters. It says it is not for the court to question the judiciousness of the decision taken by the liquidator. This is a very, very important statement. It recognizes the centrality of the liquidator in the entire liquidation process. They have referred to the BLRC in this, where BLRC also says that the liquidation part of it is a process driven by the liquidator, whereas CRP is largely driven not only by the RP, but RP and COC combined. It says that the appellant has not been able to prove in any manner that whatever the liquidator did of cancelling the Swiss challenge process and going in for a private sale process was a malified exercise in any manner. Then it talks of that well-settled principle, because here they will be quoting certain prior judgments, that where it relates to commercial matters, commercial transactions, tendering, etc., the scope of judicial review is fairly limited, only to the extent of questioning whether the process has been done in a manifestly arbitrary manner, and nothing beyond that. The court is not to substitute its own wisdom on the decisions of the tendering agency. In this case, it would be the liquidator. They have also addressed the aspect of even rejecting the highest bid, referring to Lakshmikant and others' judgment, where say that the tenderer, in this case, they were dealing with a government, state government authority, but basically that even the highest bid can be rejected. Even though it is higher than the reserve price, the highest in the process, and without even giving any reasons, the person floating the tender, the agency which is conducting the process, can reject even the highest bid. It then makes certain observations on how private sale is to be conducted in line with what the code and regulations say, that it says all that the liquidator is required to do is prepare a strategy, and whatever the liquidator has done in this particular case, it makes this very clear observation that they do not find any infirmity in the approach adopted by the liquidator. It also makes this very important observation that, and of course, this is as the regulations stood at that point of time. Today, the situation is different. That IBC and its regulations do not empower the liquidator to take an independent decision, but at every stage in this process, the liquidator has taken the stakeholders into confidence. Decision taken by the liquidator cannot be treated as arbitrary, capricious, or unreasonable. It is tempered with sound logic. It's a purely commercial decision. It has been unanimously endorsed by all the stakeholders, and it is not for this court, there is a Supreme Court, to undertake a further scrutiny. Then they go to say that a public auction definitely entails the procedure of issuing public notices, but that is not the case with a private sale. And no such procedure has been prescribed or required to be done. It can be done entirely through one-to-one negotiation by identifying by the liquidator. Then it makes the observation of the NCLAT order, which is based on, which is the one which is appealed, that the NCLT had considered all aspects and then accepted and allowed the liquidator to proceed with this procedure of private sale by negotiation with one party. That decision cannot be said to be a rushed decision for the NCLAT to have modified that order, because while NCLAT accepted that it can be done, it had actually modified the order by saying that instead of doing it only with one party, liquidator is ordered to make a public announcement that he is going to have a private sale. As I said, that statement itself is contradictory within itself. And no such relief had been sought by any party in the appeal before NCLAT. So NCLAT had gone beyond what was even asked for. So that was one of the reasons for setting it aside. There is no provision in IBC that empowers NCLAT to suo motu conduct a judicial review of any decision of the NCLT. So there is no power. It has to be done only on an appeal when such a relief is asked for or any such decision is challenged. NCLT and NCLAT cannot act as court of equity. They are summary procedure tribunals. They should stick to what is exactly what the law says and not get into details of the justice side of it, so to say. What is just and what is equitable and should it be. So finally, it sets aside the NCLAT judgment to the extent that it asked the liquidator to restart the entire private sale, sale by private treaty process. So that we are now completed what are the brief facts and observations of the court, etc. in this case. And now let us, the floor is open for questions, observations, comments, queries, whatever. Yes. Anybody has anything to ask, say, comment?
So the liquidator issued a public notice on the eve of the Swiss challenge, right, sir?
Yes. For the Swiss challenge part, he issued a notice. Yes, because he had to invite that process was it was an auction process, because Swiss challenge is also part of an auction mechanism. Whereas the second, after when he was considering the offer of Wellspun, that was no longer an auction mechanism. That was a one-to-one private sale.
Okay, so with that, so when he entered into that dealing with the RK, the Swiss challenge was stopped, is it?
No, what happened? Okay, RK Industries was identified as the anchor bidder in the second round of the Swiss challenge. Now, each round had two stages. Stage one, identifying the anchor bidder. Stage two would be the challenge mechanism actually. So anchor bidders can be identified in two ways. One is where you get an unsolicited bid, like you are the liquidator, I come to you and I give you an offer which you have not even asked for. Now that becomes the anchor bid. And then the challenge mechanism. The challenge mechanism says, I have received a bid, may identify the party, need not identify, doesn't matter. That effectively is like a base price. And then the auction process takes place. Then a highest bidder in the auction is identified. At that stage, the anchor bidder gets the right of first refusal. Having been the first one to come, he can match or exceed the price offered by the highest bidder in the challenge phase of the process. So that is still an auction process. It is not a private sale. Private sale is, there is nobody else. It is between A and B. It could be A and B and A and C simultaneously. The liquidator can very well be discussing with more than one party for a private sale process. But they don't come on the same platform at the same time throughout the process.
But the liquidator entered into this private deal process while the other public Swiss challenge is going up, is it?
See, when the second round of Swiss challenge was on, RK Industries had already been identified as the anchor bidder. During that process, it had not, now HR Commercial at that time had filed some IA before NCLT, and NCLT as an interim relief has said, you go ahead with the Swiss challenge process, declare who is the highest bidder, but stop there. Don't go beyond that. Okay, the ROFR part, etc., that would not happen. Only the challenge mechanism and identification of the highest bidder, and that is because the IA was still to be decided, whatever the IA was by HR Commercial. Now, while this was going on, this development of Wellspun came in, who Suomoto came and said, okay, I am giving you this offer. And that is when the liquidator says, okay, I stop this Swiss challenge mechanism here itself, whatever it is, and then seek a permission of the NCLT to conduct a private sale, which NCLT allowed.
Sir, in one of the matter, just I as a liquidator has given a public announcement for selling the company as a going concern basis, and otherwise the assets on different blocks like immovable assets or plant and machineries and other current assets. So during the course through public auction, the immovable properties has been sold out, plant and machinery has been sold out, but there was no taker for current assets. Current assets being intangible assets, and mostly these assets are not realizable also. Now I'm left with only the intangible assets, these current assets, and even the stakeholders doesn't want to take those assets. So how should I deal with it? The tenure is also getting over, the period of liquidation.
You are talking
so how
of,
to deal with it, sir?
Yes, you are talking of the issue of NRRA, right? Not
Right, sir.
realizable assets. Now there is a procedure in the regulations. How do you go about it? Okay.
So it is saying like it should be either transferable or assigned or sold.
Yeah,
they
you can assign no
right?
current assets.
So
Receivables can get
basically,
assigned.
so but basically the thing is correct. One of the current assets
Rashmi
is
ji,
basically
Yes, sir.
your mic is on. Rashmi Gangwal, please mute yourself. Yes.
so the current assets like the debtors and all, these are not realizable. They can take a call on that. But there is one another asset which is GST credit input,
What
which
is it?
cannot be transferred. GST credits.
GST credit. Okay. Yeah.
So this can't be transferred. This can't be sold. This can't be assigned also.
Right.
So in that case, either I have to sell the company as a whole if somebody takes it. But what will be the manner, the best suitable manner as a liquidator? How should I
No,
take it?
any, see, certain input credits like this, whether it was Senvat earlier or GST now, these
Yes,
are not convertible to cash and transferable. They are credits
exactly, yes.
available with certain conditions. Okay. When the
Yes,
condition is no longer applicable, the credit is no longer available. It is effectively that it becomes the property of the government. Okay.
yes,
That
absolutely right.
cannot be claimed automatically is property. So it is an asset which is disclaimed by the liquidator. There is a provision. Read that.
Yes, yes, disclaimer.
Assets which are
Yeah.
disclaimed. GST would, which is not transferable, would come under that.
Okay.
Current assets, also others like realizables, what you call appearing in the books, but mostly people know either limitation, fictitious entries.
Yeah, because of the
or
law of limitations.
wrong,
Yeah.
all that. So these are all can be classified under that. So when you file your final report for dissolution, you have to seek permission of the NCLT to disclaim all of this so that they just vanish by order of NCLT.
Okay, sir. Thank you, sir.
Sir, one clarity.
Yeah,
Mr.
Mr. Kabir. Rashmi Gangwal, please keep your mic on mute. Mr. Kabir, go ahead.
Yes, sir. One clarity, when the Swiss challenge was going on, like the second process, when it was operational, now when in between the liquidator decides to abandon this and really go for that other bidder who offers a composite sale price, 600 and odd crores. Now, are the facts, I mean, what came out of that second process of Swiss challenge bids, were it really disclosed before the adjudicating authority that what exactly were the bid prices that came out?
See,
this
the
is just a
answer,
clarity.
yeah.
I've been,
Yeah. Okay, I do not have the facts of that, what was disclosed or not, but I'm sure anybody would ask that question and they would have asked, what is it? What are the stages? What bids have come? We know that, typically when such a matter comes before the NCLT, first question is that, ki bid kitne ka aaya? Okay, what is the highest
yes,
bid that you
yes, sir.
receive?
Yes, sir. Yeah.
And they would have, see, the base price for the Swiss challenge was 431 crore. Okay.
Yeah.
So nobody would give 670 crore for that.
True.
Okay. And yeah, it doesn't include the land, but what was the consideration before NCLT and before that, before the stakeholders, liquidator, and then the NCLT was that even if the Swiss challenge mechanism gets 450 crore, whatever,
yeah,
it will take a minimum of 15 to 18 months to be completed after issuing sale, certificate, etc. Just removal of the material, because that is the way it was there. Okay, this was an estimate given by the bidders themselves. Ki humko itna time lagega. Okay, so after that only the land becomes free to be sold by anybody. Now, rarely would you find a person who will bid and pay for it today and then wait for a minimum time of 18 months, which could even be 3 years, for all you know, for
highly
the land
unlikely.
for that. So it was not going to happen.
Yeah,
These two, it was a combination of these two factors. And because all along, right from day one, the idea was to sell all the assets in one go. Naturally, everybody wants to do that. No?
right.
Unless, of course, they are in very different places.
Thank you, sir. The second query related to this is like, when, what should I say? See this, when this said today is the situation changed, like when this got decided and today the liquidator will have similar power to decide the way he abandoned this and then went for a composite sale. For today's case, now the live case going on is the Reliance Capital case, where also the Swiss challenge process has come up, and the price someone has now bidded more than the this anchor bidder, and a lot of things are going on at this stage. So we'll have the same kind of a power the liquidator still has, as you said, that it is also laid down in BLRC, or there are certain changes. This is for my knowledge enrichment.
Okay,
I don't know
first
about
read the
this.
amended regulations, especially the regulation which deals with the SEC constitution, powers, duties, etc. of the SEC. A significant change now is that the liquidator will necessarily have to consider the views of the SEC. Unlike in the earlier prior position when the SEC was only an advisory body and not necessarily voting on it, now there will be voting carried out for every those set of actions which require the approval of the SEC. The liquidator still has the power to reject the decision of the SEC. But, and now this is the big but, okay?
Yeah.
But the liquidator has to justify why is doing so, and it has to be done in a particular format. I think a few days ago, IBB has circulated that by way of circular. If you as a liquidator are not following what the SEC said, then please, submit your report or whatever, why you're doing so in this particular form. Now, remember this, unless you're as a liquidator have strong reasons, okay, as to why the decision of the SEC is incorrect, one would normally not do it. And at the end of the day, the sale is for the benefit of mostly those people who are part of the SEC.
SEC, true.
Now,
That's true.
naturally, people will act in their own benefit unless they are insane, right? And one would not assume that members of the SEC have been declared to be of unsound mind that the liquidator has to impose his or her decision on them. So be careful. See, the power to the liquidator is not an unbridled power. Basically, it is to be used in rare circumstances where, for example, there is the, what you call, apprehension of the liquidator that certain parties are in collusion with maybe certain related parties, promoters, etc., or some such issue on where there is reasonable grounds to believe, then the liquidator could take a different decision. But prudence would dictate, governance, good governance, that even if liquidator wants to do so, it would be advisable to go to NCLT and say that I am doing this because of these reasons. Okay, you get cloaked with the judicial approval also.
Yes, sir. Understood. Understood.
So
Thank you.
another query I have. This is like earlier SEC doesn't have the power to decide the liquidator fees. It was only the COC who used to fix it, and that was how it was dealt with. Now, with this recent amendment, the SEC has also been empowered to discuss and approve the fees or review the fees of the liquidator.
Mr. Jain,
Yes, sir.
not relevant to today's topic. Okay, let us stick to case law discussion. This is general. Kabhi aur phone
Right,
karo.
right, sir. Sorry, sir. Right, sir.
Yeah, Anu, you wanted to say something.
Yeah, there is a question in the chat box. It says whether the timelines prescribed in the liquidation process regulations mentioned under Schedule 1 of the mode of sale of auction would apply to private sale mode.
Which particular timeline is that person referring to?
So that is not mentioned. The
Not
question is asked by Mr. V. Krishnamurti. He can...
Yeah.
Yeah.
Am I audible, sir?
Yes.
Am I
Okay.
audible?
Yeah, I got
Sir?
it. Okay. I just wanted to know.
Yeah.
In general, the
Yes.
private sale process has been left to the discretion of the liquidator, and now the liquidator plus SEC. There are no timelines of, because there is no invitation of bid. So all those timelines which deal with the auction process straight away go out the window because they are not applicable at all.
Okay.
Okay?
In that case, sir, can I follow-up question on this?
Yes, yes, go ahead.
In that case, the liquidator can continue to pursue private sale, ignoring to opt for that auction, subject to approval of whatever the, not approval, subject to SEC's consent.
You see,
Indefinitely
again, I
held.
think your question is similar to what Mr. Kabir said, that
Yes, sir.
powers of the liquidator and going against the SEC. It's both these questions make the assumption that the SEC, for whose benefit the entire process is being done, are not rational people capable of taking care of their own interest. So I think we should, as IPs, keep our ego. We do have very large egos, unfortunately. If side mein rakhein, we are doing it for them. And if they say do it this way, and as long as it is legal, there is absolutely no reason why liquidator should impose his or her own way of thinking. Unless, as I said, there is credible evidence that something is hanky-panky. Okay?
Okay. Okay, sir.
Other than that, one shouldn't get into it. If the SEC unanimously decides, or with requisite majority, that private sale is a better process, what
Yes.
makes the liquidator think that no, I know better? Right? In what way are you more capable? Unless you can convince. See, if you are not able to convince your SEC, it means your grounds are anyway weak. Okay,
Yes.
we have to accept that. Okay, there are rational people sitting there, people with their money.
Yes.
You as a liquidator, you have no stake in the process. You are just employed to conduct the process. You have no stake in its outcome. So one shouldn't, the same way I would now lift what the Supreme Court said, that it is not for the NCLT and NCLAT to substitute their wisdom on the commercial wisdom of COC. Equally holds good for the liquidator too when it comes to the commercial wisdom of the SEC.
Okay.
Respect the wisdom of the people whose money is at stake, and don't get carried away by statements which are made, which are meaningless. People don't understand it. For example, maximization of value of assets of the corporator. What does it mean, really speaking?
Yes.
Anybody with
Absolutely.
any background in operations research would tell you that there is no concept called maximization in this universe, at least. There can be optimization, but there cannot be maximization.
Thank you.
But
Thank you.
these are words which we tend to throw around, because they sound very nice. Neither the person speaking it nor the person hearing it, both of them don't understand it.
Sir, maximization and optimizations in IBC context means one and the same thing. Means gains the best out of it. That's precisely.
No. I see. This is common sense, but unfortunately not very common. That is the problem. Okay.
Sir, in your slide, that 21 observation, serial number 21, that's very, very relevant and very healthy for the IBC ecosystem itself. That NCLT and NCLAT cannot act as court of equity or plenary powers. That's what is really required. Unfortunately, I don't know how far all the NCLT benches takes that kind of observation. I really don't know, sir.
No. And yes, what you are saying, absolutely right, very important. But I would add a corollary to that, or an extension of that. The same sentiment applies to RPs and liquidators. Okay, let's not,
Correct, sir.
frankly,
Yeah,
let's look at facts on the ground. Of all the registered IPs, how many have business experience? Most of us come from a practice background. All we have done is, our own small world of audit or compliance or whatever. And suddenly we are thrust into taking decisions which could be very significant, have complexities, never dealt with it. And most of us think we know everything. We know better than all the people who have come before us. So that is where, it's a red flag for the IP. please stop, think, keep your ego at home, look at facts. Okay. The same thing. Don't try to substitute your own wisdom when you can't justify. If you can justify it, absolutely, there's nothing wrong. Even NCLT and NCLAT can do it. What is the Supreme Court saying? Don't do it blindly. You need to have solid reasoning and evidence to do so.
Yes,
Yeah.
sir.
Any other question?
Yes, sir, one more question. Whether the finance, see, you said we have to go to SEC for voting for certain some matters. Whether financial matters are require any voting for SEC?
Yeah. All financial matters, everything to do with your cost, money spent. See, you go through the regulations which are amended. It lists out all those which require SEC approval. That includes basically mode and manner of sale. Okay, to decide on that. That includes appointments of all professions. All.
Just to get one small clarification, sir. In fact, in one of the cases which I am doing liquidation, I have to pay some duty under protest. The company doesn't have the money. In that case, out of the sale proceeds, I have to carve it out and I have to pay.
What is this duty under protest? One second.
That is customs duty. There is one particular.
No, there is no payment of any duty during liquidation. Huh? It has to be made converted into a claim, and please read same. I think IBC Shipyard only. The other three judge judgment on the customs case. Okay, one of the last judgments of CJI Ramana before he retired.
Yes, Sundaresh, but sir, I
yes.
Yeah.
The IBC Shipyard has a lot of landmark judgments related because it's been going on for 4 years. So quite a few issues.
Yes, sir. This is just to save time because they have to deliver the asset urgently.
No, you can't spend a single rupee beyond what is allowed under Section 53. Don't substitute your commercial wisdom for what the law says. Okay?
Right. Thank
Don't.
you. Thank you very much.
Shall we go to the next one? Okay. Before we go to the next one, what are the learnings that we take from this case analysis that we have done? That maximization of value assets takes primacy over mid-course modification or cancellation of a sale process. Why I'm saying this here as a learning? Because at the end of the day, liquidation is a process in rem, which means a public process against the world at large. It has to, by definition, because it's a public process, follow the norms in which any such process has to be conducted, which is where the public is interested. In normal course, such changes would not be allowed, but taking a cue from the objective of IBC and the timelines, etc. So the Supreme Court has generally held, not only in this case, but others, that maximization of value assets would allow certain course corrections or changes, which otherwise would not be considered as allowable. Second is that as long as tender conditions are clear and accepted by a bidder, courts and tribunals are not to interfere on grounds of equity. This is, effectively the principle of estoppel. Once you have said yes, you can't change your mind and say no. A late bid is acceptable if it is better than whatever has been received before, or the only one, which means timelines are important, but they are not cast in stone. Tribunals have no power to suo moto order modification in a sale process, especially when such a relief has not been sought. Okay, now we come to the second case. Now, this is a NCLAT judgment, NCLAT Chennai bench. The corporate debtor is Titanium Tantalum Products Limited. The appellant is the Regional Provident Fund Commissioner and the respondent liquidator and probably a few more. But I think the case started when it was in resolution and then went on to liquidation stage. Okay. Basic facts of the case. This is an appeal against the order dated December 21 of NCLT Chennai, which upheld the rejection of the claim of EPFO by the liquidator on the grounds of inordinate delay of 938 days. The claim was filed on 3rd February 2021, whereas the last date was 14 July 2018. So, and also the use of a wrong form. When the EPFO had filed the claim, they used the form from the CRP process instead of the form as specified under the liquidation process. The appeal was also filed with a delay of 106 days from the date of order of NCLT. Now that delay was condoned by NCLAT on the grounds of the suo motu SC order extending the periods of limitation on account of COVID pandemic at that time. Now, what are the submissions by the appellant? Now, appellant says it was continuously requesting the respondent, the liquidator, to disburse the sum due to it in priority over all the dues. Now, this is the PF priority issue. It has been covered in many judgments, many discussions, many talks elsewhere. I think on ICSI IIP YouTube channel itself, you will find videos on that of sessions which we have conducted on this similar issue. Because the dues of EPF are outside the liquidation estate, as held by both NCLAT and Supreme Court. NCLAT in multiple times, and Supreme Court also has upheld this both in IBC and prior to IBC. Now they say that they have been, the EPFO, okay, have been quite diligent in pursuing their dues. Right from the summons dated 14th June 2017. That means in June 2017 itself, the department had issued summons. That is a procedure under the EPF Act. It is not summons by court, but it's called summons, where they conduct an inquiry basically, and the inquiry is to ascertain the correct amount of dues. Okay, it's an inquiry to gather information. It is not a inquiry to arrive at a penalty or some such thing. No, that's not the objective. So in June 2017 itself, they had issued the summons, and despite numerous letters addressed to respondent liquidator, all those dates they are saying, the respondent had not given a reply. Okay, this is important to understand that the liquidator had chosen not to reply to these letters, whatever. Now, what did the liquidator say? He says, with respect to para so and so, etc., says, I have informed the applicant about the liquidation process as early as 26 June of 2018. 14 July or something, 2018 was the last date for filing claims under liquidation. The commissioner is well aware from 12 June 2018 that liquidation started, but they have failed to recognize that, and some TRR and challans, these are challans relating to the PF dues, which the employer, in this case the corporate debtor, has to file, because the entire PF dues is based on only and only on the data provided by the employer. Who are the people employed by them? How much PF has been deducted as the employee contribution? How much is deductible as the employer contribution? This is data provided by the employer company. PF department doesn't get it out of thin air. Okay, so when they say that this is what is due to the department, it is actually not the department. We'll come to that part later. Now, the liquidator has claimed in this submission that these so-called challans, which were uploaded after September 2018, were done by certain employees of the CD without the authorization of the liquidator. How that happens, God knows, but it says it happened. Then this is a statement made in the submissions itself. The liquidator says he suspects of a collusion between the employees and the Provident Fund Department, and then which falls within provision of Section 66, etc. The liquidator has, from what is there in the judgment, not bothered to explain how the employees or the Provident Fund Department would gain because of such a collusion. The reason I am saying this is that it is not going to the pockets of the employees of the PF department. The money doesn't even go to the government of India. It goes ultimately to the members of the Provident Fund, who are the employees, whose contribution has been partly deducted from them and to be matched by the employer. The liquidator is also saying that this claim was for the period from May 2015 to October 2017. But, based on the claim filed by the department, claim of in February 21, that the so-called challans, TRR and ECR, had been generated between 27 September 2018 and 4th October 2018. This is what he is saying, that I didn't authorize them. These were done by certain employees in collusion with the department. Okay, that's his claim. Now, these are the findings of inclined or observations. First, they say, yes, the stand of the respondent liquidator is crystal clear that the applicant was not assiduous or meticulous in projecting its claims all through the liquidation and furnished its claims lately at the fag end of the period, though they had not filed it in time, 14th July. Now, the appellant had prayed for condonation of this delay of, and it says 936 at one place, 938 at another, it doesn't matter, of these days in claiming the EPF. They had filed the claim in Form F, whereas it should have been in Form G of the liquidation regulation. They used Form F of the CRP regulation. Okay, and the liquidator had not accepted their claim, and that rejection had been upheld by the NCLT. Now, NCLAT's observations. They say that firstly, the length of the delay by itself is immaterial when considering the application for condonation of delay. It is the acceptability of the explanation behind that particular delay. Okay. In general, courts, tribunals will be very slow, reluctant to excuse any delay or to lend a helping hand to a litigant or a stakeholder who is guilty of inaction, bad faith, laches. The spelling in the judgment is wrong. Normally it is LACHES. It's not laches. It means delay or negligence. The tribunal is saying that there is an unpardonable and lackadaisical approach or attitude of the party, the PF department, in pursuing a matter before the competent authority, which is the liquidator or the tribunal, and that cannot be accepted. The law of limitation is harsh and it will affect the litigant, but it has to be pressed into service with all its vigor and rigor in the opinion of the tribunal. All very noble sentiments still now. Okay, it should. I mean, delays cannot be excused by anybody. Tribunal is saying that just because the appellant is a statutory organization, no indulgence or latitude can be shown. Law applies to one and all in a level playing field. Fine, no problem. Okay. And based on all this, they say, in fine, the company appeal is dismissed with no cause. Now, we will now stop here and open the floor for discussion. Okay. Brief case, but it has got a lot of important points. Good, bad, ugly, we will decide. Okay. So offhand, first question. Okay, let me put the question to the participants. Do you think this decision is right? If yes, why? Other than the reasons given. If no, why not?
Sir, it is right because actually, the public authorities, including statutory authorities, are also have to act diligently.
That's the decision. I mean, rationale given in the judgment. Any other reason you think why it is right besides what the NCLT and NCLAT have said? They have gone by this, that law applies equally to all. Inordinate delays cannot be condoned. Yes.
Otherwise, even after the conclusion of IBC, they will again start litigation. That's not good for the ecosystem.
Okay. Any other comment?
Sir, this is actually a little bit mechanical view I find of NCLT and NCLAT, because this is a genuine PF subject, which is always given the top priority in any of the judgments or any of the court cases, because this is employees' money, which has to go to them, and I think they should not have taken, and I cannot say against the judiciary. True that law applies to one and all, but in this particular case, because they have been sending the demands and everything from 2017, and they have failed to really comply with a process which is laid down in the liquidation part of IBC. So I think it is a huge penalty kind of a thing for them, and the employees will get affected. So that is my viewpoint. Yeah.
Okay, I will just put a scenario. Okay, just so that to make this question more, the whole thing more understandable. Especially because, as I said, most IPs do not come from a what you call employment background. They largely are from their own practice and may or may not fully be aware of the importance of things like PF dues. So I will give an example which is more familiar with all practicing professionals. Let us say that you have subscribed for public debentures issued by a company. Okay. And the company has appointed a debenture trustee as required under law. And the trustee has to perform a series of duties, primarily to protect the interest of the debenture holders. The trustee is appointed by the issuer, but is to be guided by the debenture holders only and act in their will. Now, this trustee, whoever it is, fails to perform certain duties, which could, let us take the same example, insolvency situation, fails to file claim in time before the CRP or before the liquidator. Okay. Trustee has failed. Only trustee can file the claim, right? Because the trustee acts in there. Debenture holders could be in thousands scattered all over the country. Each one of them may be small. Some may be big, some may be small. Now, because the trustee has not acted in time, the claim is not accepted or gets rejected. And obviously, who suffers? All the debenture holders. Now, those debenture holders are, who are they? They're all people sitting in the group today. Ab bolo, what is your opinion? When it is your own money at stake, what is your opinion? Who should be penalized? It's closer to home, right? When the example is closer. Yeah, exactly. This is the problem with IPs. We don't put ourselves in the other person's shoe to understand who is losing, whom are you penalizing? Can there be any penalty on the government department? Government couldn't care, right? the officials couldn't care. Not unless there is a cost imposed personally on that official for dereliction of duty. Then it is a different thing. If the PF commissioner, for example, is imposed that you shall pay from your salary, if the government shall deduct and deposit in court 50,000 rupees, तो बराबर line पे आएगा. But if the cost is that the department shall pay, they'll say, okay, who cares? Not my money, right? People understand the opinion on what is right in law or wrong in law is largely driven by how are you personally affected, which is bad. And this is exactly what liquidators and RPs should avoid, because you are not a party. You are not an interested party at all. One must learn to be unbiased and think like that. Okay. So in this case, what happened? The claims got rejected. Who suffers? Like you rightly said, Mr. Kabir, if the employees suffered. Right? भाई गलती किसी की सजा किसी और को. भाई किस कानून में ये सही है? It is against the Constitution of India. This part of the judgment is strictly against what the Constitution itself says, that no person can be punished when he is not at fault. Okay.
Yes, sir. Very well said. Well observed. Thank you.
So I will come to the next part. I've just put some issues and learnings like I did in the previous one. We'll just go through. So some questions I have raised. Okay. Could the liquidator make allegations of collusion of employees with the PF department officials without any proof? It doesn't seem to be so. So is this even in line with the code of conduct of an IP, making wild allegations against public servants and without a shred of proof, especially when such collusion, if any, if there are excess claims made by the department? Suppose, first of all, you are not going to pay without verification, but even if they are there, who is benefiting? Somebody else other than those people. Okay. So that is one question. One, that can such allegations be made by any IP in acting in any position? Now, if the employees, some certain employees, as the liquidator claims, had uploaded certain challans, etc., without the liquidator's approval, how is it the fault of the EPFO? If the collusion is not proved, somebody uploads it, they will take it, because the entire PF process runs on information provided through such challans by the company. So they got the challan on their portal. They will make the claim as per that. What is wrong with that? And they are making the claim in a fiduciary capacity. They are not making a claim in their personal capacity or as their institution. The money doesn't go to them. So when you make a statement that some of the employees did this, does it not indicate a lack of control, custody, supervision by the liquidator? So who is more at fault, liquidator or the department? I'm just raising questions, okay? These are all for us to keep in mind before we make certain wild allegations. Third issue or learning, how can beneficiaries of a trust, which is the employees, be made to suffer on account of any purported negligence on the part of the trustee, even if the trustee is negligent? How can you? Then was the liquidator right in rejecting a claim only on the grounds of a wrong form? I mean, seriously, IPs day in and day out make such mistakes and then say, oh, we are burdened with it. So kya hai, chota sa hai, so many things, condone this, accept it, go by the substance, not by the process. So hyper-technical, hyper-bureaucratic approach. Only, basically it indicates the attitude of the person who is dealing with it, but it also indicates that such people are probably not even competent to do the job of what they have been assigned. Because if the whole world works like this, which is exactly what we have been, fighting against, that bureaucracy cannot be so onerous that the end result is not achieved. The liquidator could easily have replied saying, you filed it in the wrong form. This is the right one. I am enclosing it by this email. Please fill it up and send it. Now, the substantive part. This judgment has dismissed the claims, and in doing so, it has actually gone against the law of the land, which says PF dues are above 53. So if the dues are not crystallized, are not verified, then how can they be paid? So as I said, no, it is not, it's against the Constitution, it is against the judgments of the Supreme Court, it is against judgment of NCLAT itself, which has been quoted by the department in this entire judgment. When you read this, you will know that they have actually quoted all those things. But they have all been brushed aside on the ground that, oh, inordinate. So that is this. And finally, are PF dues even a debt? Money held in trust on behalf of somebody, is it a debt? It's PF Act says it is the bounden duty of the employer the moment PF dues are accrued to collect and pay to the department, to be deposited in the account of the individual member concerned. Okay. So that brings us to the end of this session. As far as from my side is concerned, now any more questions or doubts, comments, welcome.
Sir, it was wonderful. Your session has been always very enlightening, and you know, we really enjoy. I personally enjoy your sessions. Earlier also we had interactions in other sessions.
Thank you. Thank
Yeah,
you.
it was nice to have you in such program.
Thank you.
Thank you, sir.
Thank you, Ji. Welcome. Ashok Ji, namaste.
Thank you, thank you. It was a good learning from you, and since it is every exhaustive, so there is no question, no question.
If anybody has any questions, you may please ask, or we could. Okay, so I think there are no questions. So on behalf of everybody, I'd like to thank you, sir, for making such good analysis of the cases. And it was very good. And then you made it very interactive. Thank you for the session. And thank you to all the participants also.
Thank you. Bye-bye. See you.
Thank you, Mr. Ganti.
Thank you. Bye.
Okay, also 1 second, I'd like to add one more thing, that we do have a query platform on our website. So if you have any query, you can post your queries on that platform, and your queries will be answered by our expert panel. So you can do the same.
Okay. Thank you.
Yes, thank you, Anuji. Thank you very much.